Money Radio, good afternoon, and thank you for joining us. It's time to talk real estate with Laura Bramnick from TalkRealEstateAZ.com. TalkRealEstateAZ.com. Laura is an attorney and a realtor, and she's also a consumer advocate. Good afternoon, Laura.
Good afternoon, Sinclair.
Laura is a certified instructor with the Arizona Department of Real Estate. She holds an Arizona real estate license, and she is licensed through the State Bar of Arizona as an attorney, and she specializes in real estate. In fact, she can help you with residential or commercial real estate transactions or land transactions. And most important, Laura is a consumer advocate. She works for her clients. 480-624-2705, 480-624-2705, and the website talkrealestateaz.com. Laura, last week we talked about title searches.
Yes.
Very important in case there's ever any problems.
Yes.
The idea is that everything is going to be fine, but you don't know unless you make sure that that title is in place and that there is title insurance.
Yeah, you know, it's like anything that we do, we don't get maybe the proper advice, and we try to do things less expensively and quickly.
Mm-hmm.
And a lot of times those things go through without any problems, but when you have a problem, you are so sorry that you didn't do the homework ahead of time.
And this is why it is so important that in a contract there is some way in which someone can seek relief if something goes wrong.
Yeah, contracts, you know, they should have definite conditions, and when there's a breach, you should know there's a breach. You know, it should be defined so you know what you can and cannot do. And
typically, this happens all the time, quite frankly. I mean, there's always a little hiccup or something that can happen with any kind of a transaction. And so there is something called a cure notice.
Yes, and this is relatively new with the Arizona Association of Realtors in the past several years. But what the Arizona Association of Realtors has put in their boilerplate contracts is a paragraph that says that either party is entitled to a notice that they have to cure a breach. So if one party breaches the contract, the other party actually can't declare the breach till they've served the cure notice, and the 3-day period that the cure notice allows to cure the breach has expired.
So you're looking to close on the 10th.
Right.
It doesn't happen. That doesn't mean that the deal falls apart.
No.
It means you've got to serve a cure notice, and from that point, then there are 3 days.
Yes. And just because you've breached or you've missed a deadline doesn't mean you automatically get the 3 days. The 3 days doesn't start till you're actually served with the notice from the other party.
So all those dates on the contract?
Yeah, right.
They don't really...
Not really.
Okay. But you have to give written notice.
You have to give a written notice of cure if there's a breach.
And a breach could hurt the buyer or the seller.
Yes, it's not unusual to have seller's remorse where they sign the contract. Maybe they get about halfway through the escrow period and they change their mind. I don't want to move anymore, so they serve notice that they're canceling. That would be a breach or an anticipatory breach on their part. A buyer, on the other hand, may not get their loan documents to title in time. Most contracts, or the boilerplate of the contract says that the loan documents have to be there and signed by the buyer 3 days prior to close of escrow.
Okay, so there are a lot of things that can happen. We have 3 days after written notice, a cure notice is delivered. But do we have to have a cure notice in the contract?
No, that is not required by Arizona law. It's just in the standard contract. And when I review contracts with my clients, and I use the standard contract, we talk about what would happen if this doesn't close on time.
For example, you've got dual closings,
Right.
concurrent closings.
Right, if my client is selling their property and buying another property on the same day,
Right.
they will be damaged by this. And so we have to talk about, do we want to leave that paragraph in, or do we want to take it out? Now, if I'm representing a buyer, many times the buyer's lender needs more time than the contract allows. I just find, even with the big banks, not just the independent mortgage companies, many times they need more than, let's say, 30 days. It just, the underwriting process, all the rules and regulations that have been imposed by the government, especially under the Dodd-Frank law, they take more time. And so if I represent a buyer, I may want to leave that in there, because my buyer may need those 3 days.
But at the same time, if somebody is dragging their feet or having
Yes.
a hard time getting everything together, that cure notice comes in, all of a sudden their feet are to the fire.
Yes, and that's important, because you can't really declare a breach until that happens. And then the reason that you need to do that is, let's say the deal doesn't close. There's a breach and it can't be fixed, or one party refuses to fix it. You can't really proceed on to your remedies till you've done the cure notice, if in fact the contract contains that clause. So the contract also, identifies what your remedies are, whether you can keep the earnest money, whether you can sue for damages, whether you have to go to mediation, all those, when you can litigate. So before you get to that step, you've got to declare the breach, and you have to do it legally according to the terms of the contract.
This is where what you do is so important and valuable. You're an attorney as well as a real estate agent.
Yes, so I'm familiar with the contract that the realtors use.
And most realtors are just going to take that contract, and it's generally speaking a
Right.
good contract.
Yes,
And they'll just go, yeah, here, sign here,
right.
without necessarily understanding the impact of a cure notice on a timely transaction.
Yeah, they may just assume that it needs to be in there.
Yeah.
Because that's the standard.
And they
But
can't
that's
give
not-
advice on it.
Right, but that's not the law. And so there's a difference between the standard of practice and what the law requires.
Pays to know the law.
It
Laura
does.
knows the law.
Mhm.
And she's also a real estate agent as well. So if you're buying, selling, whatever, talk to someone who can really advise you on the process. And it doesn't cost more to do that in most
Yeah,
cases.
in most cases, it doesn't. You can hire me as your realtor and your lawyer, and depending on the commission, most of the times that will cover my lawyer fees.
Laura Bramnick at talkrealestateaz.com. That's the website, talkrealestateaz.com. 480-624-2705. 480-624-2705. Good info. Thank you, Laura.
Thanks, Sinclair.